I just introduced myself. I'm Liz Moneymaker. Yes, that's my real last name. No, I did not make it up. It was my dad's name, my grandpa's name, many generations before that. I think if I made up a name, it would be something definitely that wouldn't have been so hard to live with and live up to my entire life. Um, I welcome you to April's Lunch with Liz. This is actually our third year anniversary month. I've been doing lunch with Liz's now for 3 years. Wow. And the reason I started them a long time ago, 3 years ago, is because I found that there was so much misinformation out there. And I would hear it every day from my clients. I would see it every day on social media. So I thought this would be a great opportunity to just get good estate planning, probate, trust, Medicaid information out there. And I could have done what everyone else does, which is start a podcast. But what I wanted was more of a conversation where you would have an opportunity to just in a casual environment, a free environment, and who doesn't like free, ask questions and make sure things are clarified. So how I like to work it is generally I'll give you a short presentation, and I'm going to do that today. I'm going to give you some examples, and then I'm going to open it up for questions. So you'll have plenty of time for questions. I welcome them during presentation, and then I welcome them after. The most important thing for me is that if you blocked out time to be here today and you have something you want to know. So I want to make sure you know that. So if we get to some place and I haven't addressed your question, please let me know. It would be a travesty, in my opinion, for you to leave here today to not have your question or your scenario addressed. So how today is going to work, you should see slides. It should say "Welcome to Lunch with Liz" on your screen right now. I don't always do the slides, but today's topic is a little bit complex. So I wanted to throw some slides up there for those of you who are more visual learners than auditory learners. Then we'll take the slides off and we'll just have our lunch and we'll talk about probate, talk about how to avoid it. For those of you that are just joining us, we haven't done much other than welcome you in and welcome you to the third anniversary show of Lunch with Liz. So I'm going to go ahead and get started. All right. So what is Florida probate? It is a way, certainly not the only way, and we're going to talk about some other ways today, but it is a way that property gets transferred from someone to somebody else after somebody dies. So think about the stuff that you own. Just sit here today owning, you have bank accounts, right? Checking savings probably. You might have a car, a boat, an RV. You might have investments. Those might be retirement investments. Those might be taxable investments and brokerage accounts or mutual funds or actual stocks. You might own real estate. You might have savings bonds. Some of my clients have crypto. Some of my clients have timeshares. These are all things that we own and have to have some way of transferring to someone else when we die. If you're relying on a will or a lack of will and no other mechanism, and I'm going to talk about some of the other mechanisms later, but if you're relying on a will to transfer assets, it must go through the probate process. Probate isn't the only way, and it is often the least um,
Effective.
desirable way to do it, but it is a way. So we're going to talk about that today. All right. First thing we're going to talk about is what formal probate administration looks like. First of all, the what is it? So It is where your executor gets appointed, and in Florida, we call that a personal representative. If you have a will, it's going to determine whether your will is valid. And this is where I like to put in that little plug for please do not do a do-it-yourself will. Please do not go online and print something off because you know when you're going to know when it didn't work out the way you wanted. Well, it'll be after you're dead, and it will be your heirs who figure out that what you printed off or what you wrote isn't going to work. And when that happens, when you don't go to a lawyer, there's no remedy, right? But if you've come to me and I've done something and it doesn't work, there's a remedy, right? I have malpractice insurance, for example. So I strongly encourage people not to do the do-it-yourself stuff at all for that main reason. The other thing probate does, the next area there, is it determines your heirs. And I'm going to jump to another slide. I'm going to come back to this one. But, okay, don't anybody go cross-eyed, okay? This just tells you about how the court decides your heirs. So if you have assets that go to probate and you don't have a will that names who you want it to go to, Florida courts are going to decide. And this is the chart they use. So if you're married, it goes down here. Do you have kids? No. Well, then everything goes to your spouse. If you have kids, yes, then it depends on whether those children are with you and your spouse or you had them prior to this spousal relationship. This is an area I see my clients get into trouble all the time when I'm trying to help a family go through the probate process. Because oftentimes I have clients that are in their second or third marriage, they have children from another relationship. And they don't realize that the spouse does not inherit everything if there are children from a different relationship. The surviving spouse is going to share the estate with the dead spouse's children. You can avoid this by having a will or other mechanism to transfer assets, but this is something to be concerned about if you're in a blended family. If you don't have kids, then you follow this chart here. You see way down here where it says the state of Florida gets your money. That's the last case scenario. If we can't find your 47th cousin twice removed on your far uncle's side, then it's going to go to the state of Florida. So now I'm going to jump back to the other slide. So we've talked about the court's going to decide if your will is valid. And then if you don't have a will, the court's going to decide using that chart who your heirs are. And at that point, the executor, the personal representative, is going to consolidate your assets, meaning they're going to find your bank accounts. They're going to find your brokerage accounts. They're going to see what real estate you own and just collect all of that so they can report to the court what's going on. I see some stuff in the chat. Let me just pause and see here. So if you can't see the slide, it's probably your setting. So there, especially if you're on multiple screens, it might be on a different screen for you. So going back to consolidating your assets, they're going to pay your debts, pay the taxes, pay any expenses. So expenses are going to be the lawyer. The expenses are going to be probably an accountant, might be a realtor, various people that are going to get paid out of the estate. Once the taxes are paid, the expenses to all the professionals are paid, court fees are paid, then everything gets split up between the beneficiaries and it can be closed. Typically in Florida, a simple standard formal probate takes between 9 and 12 months. So that's 9 and 12 months before your beneficiaries are going to get your assets if you are relying on the probate process to transfer those assets. All right, so I'm going to show another chart. So get your cross eyes ready for this chart. So this shows you, in a nutshell, there are some exceptions, what the formal probate process looks like in Florida. Some of these things kind of happen at the same time, But what happens a lot of times is clients will come to me about this section here where it says locating the will, and they'll come to me with the will. And then they think they're going to get appointed as executor or personal representative the next day or the next week. But this process here, where we're identifying what the assets are, we're getting the death certificate from the funeral home, we're trying to figure out who all the beneficiaries are, what all the assets are. This could take weeks and sometimes more than that, depending on how complex it is. Then we file everything with the court, and then the court says, okay, yes, this is a valid will. This person can be the personal representative. Then we have to file this called a notice to creditors. And this section here with this red arrow, this one really gets my clients upset because for 90 days, we really can't do anything because the law requires we wait. So we see if there's any potential creditors. So think about your Macy's credit card or medical bills or other types of debt. This is when they come out and file claims against the estate. Once that's done, we can then start paying off debt. We can start transferring assets and we can start paying beneficiaries. But again, this process takes on a regular, normal, without getting too crazy, probate, nine to 12 months, typically. There is another type of probate in Florida. It's called a summary probate. We try to go summary if we can, but it's pretty restrictive. You can't have more than $75,000 in non-exempt assets to go through the summary administration route unless the person has been dead more than 2 years. So occasionally we'll have clients that just want to wait to do probate because they're not in a hurry to transfer assets. So they'll wait that 2 years so they can do this smaller, less expensive probate. When I can, I opt for this way, obviously, right? It's quicker, it's cheaper for the client. If we're in doubt, it's better to just go formal because you don't want to go summary. You get halfway across the river, and you got to go back and start a formal. And now you've taken more time and more money when you should have just started at the formal to begin with. There's a lot of nuances involved in it. Well, I should have probably had a caveat at the very beginning that this oversimplifies both processes just so that you can understand how it goes. But just keep in mind that summary administration is very narrow when we can actually use it. But if we can use it, we're definitely going to use it. So, really, why you're here, right? This sounds horrible. I've heard it's horrible. I've gone through it with my mom and dad. I am the executor for my sister. I have a lot of stories like that with clients. And so they want to know, how do we avoid probate? I'm going to talk about a few examples today about how to avoid it. What I recommend, if you don't already, go talk to a holistic estate planning attorney who can walk you through all of your options. But we're going to talk about some stuff today. All right. One way you can avoid probate is through joint ownership. A lot of times with my married clients, they avoid probate because of this. They jointly own a home. They jointly own their automobiles. They jointly own their checking and their savings accounts. They are beneficiaries on their retirement accounts so that when one of them dies, there's no probate because the ownership automatically passes to the surviving spouse. So joint ownership is one way to avoid probate. Sorry, my nose itches. Somebody must be talking about me. All right. I want you to have a big red flag in your mind when you talk about joint ownership, though. And don't just use it willy-nilly without talking to your lawyer, your CPA, your financial advisor about it. Because there can be significant tax implications if you just add somebody to a deed. You can mess up homestead if you do that. You can mess up capital gains taxes if you do that. You can mess up Medicaid planning if you do that. So you just need to be very careful about adding someone to a deed. Adding someone to a bank account, be careful because once you add them to a bank account, that money is legally theirs, meaning they can take it and there's no remedy for you because it's legally theirs. Meaning if they get sued, that is an asset that now can be open to be at risk if there's a judgment against them. If they declare bankruptcy, that is an asset that's deemed their asset through the bankruptcy court. So you want to be very careful when you add people to bank accounts and any other types of assets. I'm not saying it's never a good idea. Sometimes I do recommend it. You just want to be careful about it and careful how you go about it. All right, next way to avoid probate, pay on death designations. Every bank account, every checking account, every savings account, every money market account, you can go to your bank, you can fill out a form that says, when I die, this account gets paid to X, Y, and Z, right? And when you die, then the person has to just file your death certificate in a claim form with the bank, and they get that asset without probate. You can do this even with joint accounts so that you make sure you have a beneficiary if you both pass away at the same time, for example. Next is transfer on death designations. These are very similar in concept to the pay on death designations, but think of them when it comes to brokerage accounts, stocks, because we don't necessarily want to pay those out, right? Because it may be like, you know, 3 days ago, the market, you wouldn't want to pay out those stocks, when the market was at its tanking 3 days ago. You want to transfer the stocks. So now the new owner decides when and if they're ever going to sell. So it's the same concept, it's just a different phrase. So I wanted you to understand both of them. Next is beneficiary designations. Think about your retirement accounts, your 401ks, your SEPs, your Roth, life insurance policies, and annuities. All of those have the ability to have beneficiary designations. And when you give a beneficiary designation to those assets, that is who that asset transfers to at death. So that is a way to avoid probate. This next one is a tool that we have in Florida. Not many states have a similar tool, but the way I like to describe a ladybird deed is it's a way to put a beneficiary on your deed so that when you die, your house, your condo goes directly to the person that's listed on the deed. They don't have ownership in it before you die. Don't have any controlling interest in it until you die. You can still sell the property, refinance the property, do whatever you want to with it, but upon your death, it goes to the beneficiary on the deed. It is not without its drawbacks, and I always talk to my clients about what the drawbacks are, but it is a very good tool to avoid probate in Florida. And then the last one I want to bring up here is if you have a properly funded living trust, you can use that to avoid probate. Usually I'm using a living trust in conjunction with some of these other options here on this list so that we can avoid probate. When I'm talking with clients, what I'm looking for is, hey, what is the least complicated, most cost-effective way to accomplish your goal? And if your goal is to avoid probate, we often can use a lot of these strategies to avoid probate without getting into more complex trust-based planning. Sometimes, though, you need complex planning. Do you have minor children? Do you have special needs children? Are you in a blended family? Do you have a non-citizen spouse? Do you have property in multiple states? Do you own a business? If you answer yes to any of those, Congratulations. You're in the more complex planning arena, and we may not be able to only use these strategies. We may have to use more complex trust-based strategies to avoid probate and to accomplish your other goals as well. So before we open it up just for conversation and questions, I want to give you just some examples. So in this scenario, this is a very, very, very common scenario that I get in my practice. So there's a client that comes in, they own a house, they have a checking and savings, they have a brokerage account, and their retirement accounts, and they've got life insurance. So right from the get-go, you know from the previous slide, right, that the bulk of these can be transferred just with transfer on death, pay on death, and beneficiary designations, as I've listed there. And then we can do a ladybird deed for the house. So without doing too much, we can then avoid probate. Next example is if we need to use a trust to avoid probate. The reason I call it the bucket is I like to think of a trust like a bucket. And let me just do a side conversation here for a second. The problem with trust that I see a lot on a weekly basis probably is people go online or they even go to a lawyer and they get a trust. So they come home with this 50-page pretty thing in a binder and they put it on a shelf. But what they have is an empty bucket because nothing is actually funded into the trust. Just because you have a trust printed out and maybe even on the back page it says, all your assets are in the trust, until you actually do the funding of the trust, you have an empty bucket and you've actually just created more expense and more work when you die versus less. But let's go through this scenario. So in this scenario, we have Sarah who owns a house in Florida, a place in North Carolina. Just like the guy before, she has a checking and savings account, brokerage, retirement, and life insurance. So for her, because she owns that property in North Carolina, it's more complex planning. I can't just do transfer on death deeds. So for her, one way that we can avoid probate then is we create the trust. So we create that bucket for her. We put both properties into it. We title her brokerage account and her checking and savings into the trust. And then when I say maybe you make the trust the beneficiary, it just depends on what she wants to do with that money because the trust could, the life insurance retirement could still go directly to other beneficiaries and avoid probate. So this just kind of gives you the idea of how we have those tools and how we can use a combination of them to help people avoid that probate. So I have chatted now for about 25 minutes. So what I want to do then is I'm going to stop sharing my screen and I am going to open it up for your questions. And just so you know, I just stop sharing it. Vicki will share these slides with you at the end. So you'll have this takeaway to refer to as you decide how you want to do your plan. For questions, feel free to throw those in the chat, or you can come on either video or non-video. It doesn't matter to me, and ask your question or get clarification on something. If there aren't any questions, then great. You have an extra half hour of your lunch. But if there are any, just go ahead and let me know. I don't think we have any in the chat yet, but let me check. No, I don't see any in the chat yet.
My apology. Did you want the questions in the chat or just to unmute?
Either way, Marilyn.
Oh,
whatever
okay.
floats your boat.
Okay, thank you so much. First of all, let me say this. I did not know your real last name was Moneymaker. That's the first thing. Thank you. That was the first time I heard you say that. So thank you. I've enjoyed this session before. It's been very, very helpful. And I will say today, man, your explanation was top notch.
Oh, thank you.
I have more understanding today than I've ever had. So thank you very much.
Excellent.
The when we talk about in that scenario that you had on the one slide, so you have a home, you have checking, savings. What about business accounts? Are those is that handled differently if you have a business as far
It
as
it is, Marilyn. So that you may have heard me say you might not fall into the least complicated, most cost-effective way if you have certain situations. And being a business owner, depending on how you own the business and what type of business, that is one of those scenarios. One of those reasons is because business accounts don't can't have pay on death or transfer on death beneficiaries. And you can see why, right? Because you have this business account that might be used for payroll or might be used for accounts payable. So you don't want that account to be drained out when the owner passes away. So when I have clients that have businesses, we need to do a whole conversation about making sure that the business strategy for succession and death or disability lines up with the personal succession planning. Some of that I do, some of it, depending on the type of business and if there's multiple partners, I'm going to suggest we bring in a business attorney to make sure that all those parts jive.
okay? I have one last question and I'm done.
Yeah,
The
sure.
summary version, could you maybe kind of go over that again? I was just trying to figure out, you said if it's been at least more than 2 years. So if it's been more than 2 years, what happens in the summary version? If there's not a lot of assets other than, the home, even the bank account, I don't believe there was much of that there, but let's just say it's just really a home and not much else.
Yeah. So in the summary, and I do have that happen quite a bit. So let's say it's 2 years, more than 2 years post somebody's death. We don't get a personal representative then, so there's no executor. We just file documents with the court that shows that the person has been dead over 2 years. And as long as the non-exempt assets are less than $75,000, we can transfer those. A homestead asset is exempt, so that doesn't count towards that 75,000. So oftentimes in these
Oh,
cases, I have maybe a homestead that, grandma had and family's been living in there for 20 years and no one thought to transfer the asset. Well, we can do that through the summary process and also transfer the bank account.
okay.
And
Gotcha.
usually that takes 2, 3 months. So,
Gotcha. Okay, thank you. I have another one, but I'll let somebody else ask a question first.
all right, I'm going to jump over to the chat then and just take them in the order that they came. So, I had one. Um, Hi, Liz, you mentioned non-citizen spouses. Does that also include if the spouse has a green card but not yet a citizen? It does. There are estate tax ramifications for non-citizen spouses, so even green card citizens. It doesn't impact everyone, but it's a conversation you'd want to have with your estate planning attorney to make sure that we're addressing that in your plan. Next one. What is the best way to find an attorney in the state of residence? I've emailed a few and not gotten a response back. Well, so Chris, I'm assuming you're not in Florida, or you be calling me. Um, well, um, there is your bar association. So the bar association in each state is who regulates the attorneys in each state. That's a good source. They usually all have lawyer referral services. Um, your county, like in our county, we also have a bar association, a local one that would have estate planning attorneys in it. So that is a referral source as well. And honestly, good old Google as well. I'm happy if you want to tell me where you are, I might know somebody, or at least can give you a reference. So happy to. I think my Vicky's email was up on the other slide, but she can throw that into the chat for you and just email us and we'll see if we can help you find somebody. All right, next question. If you have several checking accounts and the person who is joint owner, I think it means is only on one, are your other accounts in trouble with the bankruptcy courts? I think Pat, correct me if I'm wrong, but I think what you're saying is let's say you have a joint owner on the checking, but they're not joint owners on other accounts, it's only the one that you're joint on that you would need to worry about any liability for that joint owner's debts or litigation. So not your other assets, just that one. Next question. Is it better to buy investment properties in an LLC or a trust or a real name? We would only hold them less than a year. Ooh, that is a big question, and a lot of depends on that. It depends on what you're doing with properties. Depends on whether you're mortgaging the properties. Um, so typically, I don't suggest putting investment properties that are going to be rental properties in a trust. If it's just land that you're holding on to resell, then maybe. Um, but it just think about it this way. LLCs can be a great way to shelter liability, but if it's a one person LLC, it's in Florida really not a good liability shelter anyway. So I'm gonna shut up on that because that's a lot bigger question than probably under this probate umbrella of this lunch with Liz for me to answer. Next question. If a family member can't be the executor, can anyone I choose be that executor? Are there people who execute trusts for a living? Yeah. So let me just kind of go over the vocabulary there for Florida, just to make sure everybody's clear. So in Florida, we use the term personal representative, but that means executor, and that's for the will. The person in charge of your trust, if you have a trust, is called the trustee. So if we're specifically talking about a will, and that's the personal representative, there are there are limits as to who can serve in that capacity in Florida. Florida says you have to be related to the person who's going to be personal representative, or you have to be a resident of the state of Florida. If you're a resident of the state of Florida, you do not have to be related to the person. But if they live in Michigan or they live in another country, they have to be related to you to be personal representative. However, for the trust, if you do that whole bucket plan and you have a trust-based plan, your trustee can be anyone that you choose. You don't have that same requirement to be trustee. Now, if you're my client, we're going to go over all the perils of how to choose a trustee and all the problems that can arise with who you choose. There are professional fiduciaries in Florida, well, all states, but in Florida, we have professional fiduciaries that will act as trustee, that will act as personal representative, even as power of attorney and your healthcare power of attorney. So yeah, there are those. I have a lot of clients that use those services because either they don't have family or they choose not to burden their family or they're estranged from family. So they choose to have a professional trustee. All right, next question. I have a pour over will into my revocable living trust. Will you please explain how this is utilized in the trust? Yeah, that's a great question, Anthony. And I was going to go into it before when I was creating the presentation, but I thought it got into the weeds. But this is a perfect time to bring that up. So you'll often see, especially on social media, I see it all the time. Should you have a will or a trust? And it's really not a question of a will or a trust. If you have a trust-based plan, think again of that bucket analogy, right? So I've created a bucket for you, and we've put your house into the bucket, we've put your accounts into the bucket. You've got this. Well, I'm also going to create a will for you as well for several different reasons. One is the will's going to say, if I forgot to put something in my bucket, or I got it after the trust and I didn't get around to putting it into my bucket, I want my bucket, my trust to control that asset. So that's number one. That's why they call it a pour over will, because it pours anything that wasn't was unintentionally not put into the bucket. The other thing that the will does is what we've already talked about here today. It names a personal representative. That can be important because sometimes people die through someone else's negligence, a car accident or medical malpractice. And it's only the personal representative that would have authority to deal with filing a lawsuit or filing a claim. There could be post-death issues with Medicare. other insurance companies, the IRS, Social Security, and only your personal representative has authority to deal with those. So that's why the will is still important. If you have minor children, the will is where you're going to name your guardian. So when you have a trust, you're going to have a will. But when you have a will, you don't necessarily have a trust, if that makes sense. And if I've answered your question from the chat and it does, you need a follow-up, just please let me know. Oh, how does your pour over trust work? Do you have to go through probate? Well, that's a great segue. Thank you. Thank you, iPad Pro. Um, so remember when I said you got the bucket and the will says, hey, if I forgot to leave, so put something in the bucket, I want it in there. Yeah, you have to now probate that asset to get it into the bucket. So it's not ideal, but at least then you have the bucket instructions controlling. Remember a little while ago when I said be careful about the do-it-yourself stuff? This is what happens a lot with trusts is someone creates it on their own or they go to a lawyer, they don't fund it. So now they've got this pour over will, they've got an empty bucket. So now we have to go through the probate process to put everything into the bucket, and then we have to administer the trust. So we're doing double duty and we're paying double duty for that. So it's extremely critical when someone has a trust, they say have a trust plan. Is their trust funded? Do they have everything in their bucket? Another question, if a piece of property in another state is the only complicating factor, do you still need a trust? It depends. Some states do have transfer on death deeds that are similar to our Ladybird deed. And if that's the case, I do have some clients like that where we did avoid a trust-based plan. But if you don't have that, then if you don't do a trust-based plan, your heirs have to probate in that state where that asset is. So maybe you avoided probate in Florida, but now they need to go open a probate in North Carolina where your other property is. So that's why we a lot of times do go with a trust-based plan when we have those out-of-state properties. Um, how much does a trust cost? I'm going to give you the lawyer answer. It really just depends. Depends on, is it individual or is it joint? Are we dealing with special needs or minor children? Are we dealing with a complex distribution plan? Like I've got some with 20 beneficiaries and you know, if this, then that. I would tell you that if it is a joint based trust, like a married couple trust with adult children, and we're not putting a bunch of strings controlling from the grave, then the trust-based plan, which includes all the other documents that we haven't talked about today, but the will, the power of attorney, the deed, all of that, it starts at 3,500. So that gives you an idea of where a joint trust would cost from me. Next question, do I think a testamentary trust is a good idea? So what a testamentary trust is, it's a trust inside the will. So when I talk about the bucket, that's like a living will. That's why they call it. It's living because it's alive now. A testamentary trust lies dormant and only comes out of the closet when someone dies. And it's created through the probate process. So a testamentary trust does not avoid probate. It just means that during the probate process, you're creating the trust. I think that there are times when we put testamentary trusts in action for parents with minor children, for example, and I call it the roll the dice plan because they're planning to be healthy and alive while and their children become responsible adults, and that is never needed. But just in case, it's there if they were to die while their kids are minors. It doesn't save any money and it doesn't save any time. So is it a good idea? It can be a tool, but I guess I wouldn't call it a good or a bad idea. It's mainly weighing the consequences of one way versus the other way. Pat says, so if your home and investment accounts are titled in the trust, it is considered funded. Yes. So you want to make sure it's fully funded so you don't have any other assets that are dangling outside, but that's what I would call a funded trust. Yes. Um, Next question. If we have assets, real estate, for example, in Florida and overseas, can these documents that are created in Florida also protect the assets overseas? Can you even own properties owned elsewhere in these documents? So you can own properties in the United States for the Florida trust that I would create for you. You can't do the same for overseas property. So I have clients that own property in the UK, in Portugal, and Spain, and France. They have to go to an attorney there and deal with their assets in the way that that country requires. I have a lot of people from Canada too that come down here. They have a Canadian estate plan and they've got a US plan to how to deal with their assets. Um, what does funding mean? Let me just go over that again. So you've got the empty bucket, which is just the piece of paper that says it's a trust, right? Funding means so Christine, say Christine owns a house. Funding means we've deeded the house and now Christine's trust owns the house. It means now Christine's brokerage account isn't named Christine's account, it's named Christine's trust account. Same thing with bank accounts. So it's making sure that the title of your assets is in the trust name and not in your individual name. Next question. Are timeshare properties considered real estate? And if not, in trust, what then? So the deeded ones, there's different kinds. There's deeded ones that are considered real estate, and we can deed those into the trust. And then there's other kinds that it just depends on what your contract is with the timeshare company as to what happens to it. Um, More importantly, too, with timeshares is so they're in the trust. Well, what happens to them? Like, are you making sure they're going to go to someone who actually wants them? Because now your trustee is going to have to deal with them. So that's an important discussion to have with your attorney about ultimately what's going to happen to the timeshare. Next question. In my opinion, what is the best way to leave a home to your adult children with the least amount of negative tax implications? Marilyn, that's going to just depend on everyone's different situation. But I would tell you that oftentimes it is the ladybird deed, which is the least complicated, least expensive way to transfer to your adult children. They inherit it the same tax base wise as if it was through a will or a trust. So that's good. And so to me, that's the least amount of complications and then the easiest way to do it. But that doesn't work for everybody though. And I would want you, whoever your attorney is, talk to them about the pros and cons of a ladybird deed for sure. Talk about funding the trust. Ensure you notify the homeowners insurance. Yes. Yeah, Anthony, that's great. In our letter, when we send, well, we talk to our clients about that, but when we send the deed out to our clients, we always remind them, if you haven't already, talk to your homeowners association or your homeowners insurance to make sure that the trust is listed as an insured on your insurance because they can look for any way to deny coverage. So we want to make sure we take care of all that. All right, I'm going to take a quick drink of water while I see if there's any other questions. And if I didn't answer one of your questions, so I skipped it, let me know. Or if you wanted more clarification from something from the chat, let me know that too.
I have another question, but
Sure.
my
Yeah.
fingers are not typing fast enough. I need to get my nails done. So sorry. So, as far as an executor over a will, can you talk about the responsibilities of the executor, in addition to, say, if there are other family members or siblings, if you will, who have a little more hands-on in some of the details and information that they won't give access to you to properly execute the responsibilities. I hope I'm saying that right. Let me see. Let me see. How do I get a little more detail without getting detail? Okay. So let's just say you're the executor.
Let's do hypothetically, Marilyn, what's
Yeah.
going on?
Hypothetically, if you're the executor over a will, the person who put you in that position has passed, but your sibling has found a way to get in finagle and has access to information that you don't have on the deceased family member. But you were the executor that the deceased family member left in that position. So, how do you properly exercise the responsibilities of the executor? Like, what is it that an executor should, what are your responsibilities, Liz? I'm sorry. This is hypothetical. Hypothetically, what are your responsibilities if you don't have access to the information to do what you need to do to make certain that things are divvied up properly and go through probate and all that stuff?
So lack of information, is that you mean like lack of access to an asset?
Right. Yes.
Or well, let's step back for a second. So when you are named a personal representative or a trustee or an agent under a power of attorney, you become a fiduciary. And that word is super fancy because it is super important and carries a lot of financial responsibility. When you agree to be personal representative, you are agreeing to safeguard the estate's funds. You are agreeing to diligently marshal all of the assets, to prudently negotiate and pay debts. And ultimately, your job is to ensure that the beneficiaries get what they're supposed to be getting from the estate. So if you have a person, whether they are a beneficiary or not, who's impeding your ability to do that, it would be in your best interest to talk to your attorney and then potentially have the judge get involved and issue a court order.
Okay.
Um,
Got it. That was
mhm.
very helpful. Thank you. I think I'm done. Thank you so much.
Well, it's
Thank
okay if you're not. We have a few more minutes.
Okay, gotcha. Thank you.
Next question. Are there any detrimental financial consequences to redeeding ownership of property from a private person to a trust? Not sure I understand that. Are you talking like if I own a property and I deed it to my own trust? Is that if that's the question, no, because the trust carries my social security number, so it's the same. So there's no tax consequences at all. There's no homestead issues in Florida. I call it a transparent transfer. Um, so there's no
So
problems with it.
for example, everything we already own is in our personal names, you know, like you said, with our social security numbers on it. Is it a, I get, because I apologize for my ignorance, is it a huge ordeal to take CJ and Patrizia's house and make it into a trust ownership and take it out of our name and put it into a trust ownership type situation?
No, it would simply be a new deed. So you would deed it
Okay.
to yourself as trustee of your trust. It's a deed is something I include. I include the primary home deed, and when I'm doing a trust-based plan. If you have additional properties, then we talk about, what we should do with those. But your homestead property, very simple process to deed that into the trust. And then if you decide to sell the property, it's easy. If you purchase a new property, you just have the title company, the closing agency, title it in the trust name. Where there can be, since we have a little bit of time here, where there can be some issues, and I've had this happen with clients, is so they have a place in the trust and now they want to refinance the house. And a lot of lenders, not all of them, but a lot of them will make us deed the house out of the trust. So take it out of the bucket, refinance it under your individual names. And then once it's refinanced, we can deed it back into the bucket. So if you're thinking of refinancing, which I don't think anyone would right now, but if you were, you want to do that timing right of when you want to deed it into the trust.
Okay, thank you.
You're welcome. If two people have a trust together and they are not married, if one dies, can the other person still sell the property without probate? Yeah, two people have together and they're not married. Don't usually do joint trust when they're not married. Um, but assuming that's true for a moment, then yeah, you would still sell it without, because the trust would still own it. So typically in a joint trust, the survivor person is now the trustee and they can do whatever they want with the property. Typically, sometimes we write it where they can't, but typically they can do whatever they want. Um, yeah. So you said they're trustee. So yeah, they can still sell the property without probate. Yeah. Yes. Hopefully that answered your question, Jacinda. Marilyn, can you elaborate further on a ladybird deed? Not sure what more I could say other than you think of you own a house. So Marilyn owns a house. And now we're going to do a new deed. And the new deed says, I, Marilyn, am deeding this house to myself, Marilyn, for the rest of my life, or for as long as I want to own it. I can sell it. I can do whatever I want to with it. But when I die, it goes to Liz. And then when you die, I just get your death certificate and I file it. And now the house is mine and it avoids probate. That's really, think about it as a life insurance policy with a beneficiary on it. It's a deed with a beneficiary on it.
Okay. Do you have to refinance with the lender when that happens?
Oh, absolutely not. No.
Oh, okay, gotcha. Thank you. Okay.
Yep. Carol asks, are trust amendments included in the original cost? For me, no. No. Trust amendments I do at my hourly rate. Depending on why they're getting amended. Typically if I have clients get married, I do it as a gift, for example. But if we're amending it because we're changing trustees or amending it because we're changing distribution plans, I charge it at my hourly rate. What happens if the trust documents are lost? Oh my goodness, there's so much case law out there about lost trust documents. Um, Sometimes we can just create a new trust with the same name, especially if we just have a copy of something. Um, but typically you have to go to court and get a court order and try to argue what the original grantor's intent was. So definitely good idea to always, for example, when my clients come, they go home with their originals, but I keep electronic copies and they get electronic copies. So generally speaking, there's always going to be an electronic copy of something out there. A dumb question. There's never a dumb question. If my executor is not the brightest crayon in the box, would doing one of those end of life planners make this process easier for them? Like the next of kin boxes, I think that's what you're referring to. I think those are great, no matter if your executor is bright or not. The easier you can make it for someone, especially if they're a close family member who are going to be grieving anyway, the better. I have a good friend of mine right now that was named personal representative of one of his friends' estate, and he left it in a way that I'm just so angry for my friend because there's boxes and boxes of stuff and properties in multiple states, and it's just a mess. And that's just kind of a mean thing to do to someone that you're allegedly good friends with. So yes, love next of kin boxes. I love anyone that has all their stuff all in a binder, so all their beneficiary forms, account information, all their wills, their trusts, all those types of documents. That would make it way easier for the person that's going to take over for sure. Oh yeah, Vicky just sent the slides that we had in the session. I know we had some people that have already signed out too, so we'll make those slides available some other way too for anyone that popped off early, and for those of you that are going to be watching this later as it's recorded. If I didn't get to your question or you have another one, Vicky put her email in the chat. Just shoot her an email and she can set up a time to chat. We do complimentary consultations for estate planning, so can give you that holistic look about what you can do to make sure that whoever you're leaving your estate to can rest easy knowing you've done everything you can to dot all your I's and cross all your T's. So, all right, thanks everybody for coming. You've been a great group, very, very inquisitive and great questions. Really helps, I think, flesh out all these um, complicated issues. So, all right, we will see you next month if you decide to come to lunch with Liz. All right, everybody, take care.